Hey guys, Sri Lanka Sammy, Itaewon Sammy, back with you today. I'm going to talk to you today about civil and labor law differences in Korea. Coming from sunny Sri Lanka, I want to thank everybody who is following me, liking, sharing, commenting, etc. For those of you who are new to my channel, thank you for watching. I am a Canadian citizen, dual Canadian Sri Lankan. I've lived in South Korea for 13 years and I retired, semi-retired just a month ago, and I want to share with you some of the issues that I have seen working in Korea. Now I'm a permanent resident in Korea and I have experienced a lot, so hopefully I can shed some light on this issue and help you if you have any questions. So a lot of people come here and work, and there is some confusion in the laws here compared to Western countries. There's a big difference. Number one, if you're coming here on an E2 teacher's visa or any visa, there's a difference between labor law and civil law. So I'll start off right by number one. Anything you sign, regardless of what it is, if it's in violation of labor law, it's not applicable. So for example, if you sign a contract saying I gotta think of an exact example. So there's so many, but it's a gray area. So for example, if you sign a contract and in the contract it says you waive your right to severance, although you signed it, it is legally illegal. You waive your right to here's a perfect example. In the contract it says you have to give 90 days notice of termination. Absolutely illegal. Not illegal, it's not enforceable because that is a labor law. And any contract cannot supersede labor law unless you give explicit permission. So for example, let me take a step back. Most contracts say you have to give notice. And as a Western culture, we come from North America or Europe, and 2 weeks notice is what is normal. 30 days notice is what is normal. In Korea, no. Regardless of your visa, regardless of your status, you can give 1 second notice and walk out, and you're not liable for anything. On the flip side, secondly, unless you give explicit permission, like for example, I authorize, and this has to be a separate agreement, I authorize company ABC to withdraw my electricity bill from my pay. Now, I would never do that because your pay is tied to your severance. So the less pay you get, the less severance you get. So try to get as much pay as possible, thus increasing your severance at the end of your contract. What's something else? So under labor law, the amount of hours that you work. Under immigration law, the location and the name of the company that you work for are strict. That's not a labor law, that's an immigration law. Next, civil law. Your housing and your sick days are civil. There is no housing law required. That is a civil thing. Paying for your flight ticket home is civil. Your sick days is civil. There is no labor law. Maternity, yes. Maternity law, yes, but not sick days. That is purely civil. And now in the world of COVID, if you're forced to quarantine, that's a sick day. No work, no pay. I mean, that's just normal, okay? So let's talk about notice. Contracts always say, give 30 days notice, 90 days notice, or whatever. You only have to give notice, and then you can walk out. When you quit, that's it. You walk out, you don't know anything. If you're on an E2, you have 14 days to leave the country from your last day of work. You have 12 to 24 hours to vacate your company-owned housing unless they negotiate with you. Regardless of what your visa, your ARC says, if you're an E2 and you quit and you walk out, they will notify immigration at that point, and you have 14 days to leave the country. If you don't, you're in violation, or you don't change your visa. They do not have to give you an LOR, letter of release. There's no law on that. You can negotiate it, but it's up to them. Ministry of Education and Labor will not help you with civil. Immigration will not help you with your contract. Okay? Immigration is only care about one thing. So think about this logically. Your contract is submitted to immigration. If it has violations in it, it's still accepted because they don't read it. They just keep it on file. All they care about is that the minimum amount of hours and the minimum pay is met to not conflict with immigration law, not labor law. They're not the labor department. They don't care about labor laws. So everyone always says, oh, that contract is illegal or written wrong or what have you, but immigration still accepts it. So logically, they're not checking. Because why would they accept a contract that is illegal? They're not. So think about that. They don't care. So they're not going to help you if there's a violation. Ministry of Education and Labor will help you with violation of labor law, and the Labor Relations Board will help you with that as well. And then a civil lawyer will help you with anything else. Now, companies also say that they will try to recoup their losses. They will say they will sue you for damaging their business. Not possible. Unless you blatantly violate and badmouth them or cause through your work to cause damage to their business, then yes, they can sue you. But just quitting is not causing damage to their business. Absolutely not. That is not a legal precedent. Doesn't exist in law. Doesn't exist in civil law. Then think about it logically. If you quit any job, that causes damage to the business. What is damage? Money. They have to hire somebody, the reputation of the business, etc., etc. That means nobody would ever be able to quit, because then everybody would be sued. I have never, in 13 years of living here, heard of anyone ever being sued for damaging a business. It just doesn't exist. Well, it does. It has happened. It does exist, but I haven't heard of it. Because it costs more money than you can recoup. And then if the teacher leaves, they're judgment proof. They don't have any money. What else? So we have that. We have housing. They cannot take any money, landlords or what have you. They must, by law, return your full deposit the second you walk out the door and hand over the keys. Under Korean law, if you do not get your deposit, you do not give the door code. That's it. Unless you're breaking the lease, then you deduct the remaining months of the lease. Like in my case, I left 4 months left on my lease. So they deducted 4 months of rent from my deposit and returned the deposit to me the minute I walked out the door. Now, they rented it a month later, so I got 3 months returned to me, which was really cool. I had a good landlord. They were really cool about it. When you take possession of your property, the condition it's in is your acceptance. So anything that happens afterwards is your responsibility. So make sure you accept it and document the condition. It's technically it's their word against yours, but it just causes so much trouble. Have the proof. You know, in this case, it's like guilty until proven innocent. It's a big pain in the butt. So basically, what you need to do is you need to cover your butt. Don't sign anything, cross things out, and say, no, I don't agree to this. They're not going to not hire you. They need you. Download the labor law app, Korean labor law app from the Play Store or iStore in English and read it. Read the featurettes on the Loft board, the feature tabs on the Loft board on Facebook. Wow, it's hot. It is really hot today. It's like 4 o'clock in the afternoon on a Friday. I'm just relaxing and enjoying. I hope you guys are safe, healthy, and happy. Don't stress about things. You are protected. You do have rights. You are protected. You are safe. So don't stress about things. Enjoy life. Stay happy. Stay healthy. Sri Lanka Sammy, Itaewon Sammy. I'm out.